They can't do this. The courtroom fell silent. Maya Bennett stood frozen, staring at the television screen mounted above the clerk's desk. The decision had just been announced. 4 words echoed across the chamber. Judgment reversed. Case dismissed. Her son's photograph slipped from her hand and hit the marble floor. If you believe the law always protects the innocent, subscribe to Sweet Justice right now and comment your country below. Because today's story is about a ruling many would later call one of the worst Supreme Court decisions in state history. 3 years earlier, Maya's husband, Officer Daniel Bennett, had been killed during a private security contract gone wrong. Thickies, contractor firm, Redmont Security Solutions, had deployed officers without proper equipment. Evidence later revealed falsified inspection reports. Daniel had reported safety violations weeks before his death. He died during a warehouse explosion. The state trial court found Redmont negligent. A jury awarded the Bennett family $18 million in damages justice. Or so Maya thought. Redmont appealed. The appellate court upheld the verdict. Justice. Confirmed. Then the state Supreme Court accepted review. No one expected that. Redmont's argument was technical. They claimed sovereign immunity protections applied because the warehouse was operating under temporary emergency disaster designation, which meant, if accepted, they could not be sued. But Redmont wasn't a government agency. They were private contractors. Still, the Supreme Court took the case. The oral arguments lasted less than 1 hour, less than 60 minutes to dissect 3 years of grief. Maya attended every hearing. She watched the justices question aggressively, not Redmont's negligence, but jurisdiction. Jurisdiction. Her husband died, and they debated paperwork. Subscribe now if you've ever seen justice reduced to technicalities. The decision arrived 8 months later. 3 majority. The court ruled that under emergency executive designation, contracted entities performing state-sanctioned disaster response functions were shielded from civil liability. Redmont was protected. The verdict was erased. No compensation, no accountability. Daniel Bennett became a footnote in a legal interpretation. Maya felt the room spin. Reporters swarmed outside. "Mrs. Bennett, how do you respond to the Supreme Court decision?" She didn't answer. Because how do you respond to being told your husband's death is legally inconvenient? Inside the marble building, Justice Raymond Collier, author of the majority opinion, gave a brief statement. The rule of law must remain stable, even in tragedy. Stable. The word burned. Meanwhile, dissenting Justice Elena Vargas wrote a blistering minority opinion. To extend sovereign immunity to private contractors is to dissolve accountability itself. Her dissent gained traction online. Legal scholars debated, editorial boards criticized. But legally, it stood. The decision was final, and that was the worst part. Until something surfaced. 2 months after the ruling, investigative journalist Aaron Pike published an article. Buried in state procurement archives was a memo signed 6 months before Daniel's death. It showed Redmont executives meeting privately with legislative aides, lobbying for expanded emergency liability shields. The meeting notes referenced anticipated litigation exposure. Anticipated, meaning they expected lawsuits before Daniel died. Maya read the article twice, then a third time, and for the first time since the Supreme Court ruling. She felt something other than grief. She felt suspicion, and suspicion, when directed at the highest court in the state, is dangerous, very dangerous, because if the ruling had been influenced, if lobbying shaped interpretation, if immunity was expanded deliberately, then what people were calling one of the worst Supreme Court decisions might not have been a mistake, it might have been engineered. The article spread faster than the original ruling. By sunrise, every major outlet in the state had picked it up. Did lobbying influence the Supreme Court's immunity expansion? Private meetings before landmark decision? Was this one of the worst Supreme Court decisions, or something worse? Maya Bennett didn't care about headlines. She cared about one line buried halfway through Aaron Pike's investigation. Redmont. Executives met with senior legislative aides to discuss emergency liability reform weeks before filing their appeal. Weeks before. Not after the accident, before the appeal. Before the Supreme Court even agreed to hear the case, which meant they were preparing for immunity long before the ruling existed. If you believe power rarely moves without preparation, subscribe to Sweet Justice right now. Because this story is no longer just about a ruling. It's about influence. Maya called Aaron Pike directly. "I need to see everything you couldn't publish," she said. There was a pause on the other end. "That's not how this works. My husband died because of them." Another pause. Then Aaron spoke carefully. "Meet me." They met in a quiet cafe 3 blocks from the courthouse. Aaron was younger than Maya expected. Sharp eyes, controlled voice. He slid a folder across the table. "These are procurement communications," he said. Redmont was negotiating emergency contracts months before the warehouse explosion. Maya scanned the pages, dates, email chains, budget allocations. Then she saw it, an internal message from a Redmont executive. "If immunity bill passes this session, liability risk becomes negligible." Negligible. Maya's hands tightened. "Did the bill pass?" she asked. "No." "Then how did they get immunity?" Aaron leaned back. "They didn't change the statute. They changed the interpretation." Maya looked up. "The Supreme Court did." Aaron nodded slowly. "That's why this is explosive. Because if the statute didn't change, and yet immunity expanded, then the majority opinion wasn't applying law, it was redefining it. Subscribe now if you've ever seen how a single paragraph can reshape accountability. Meanwhile, inside the marble chambers of the court, dissenting Justice Elena Vargas was not celebrating anything. She reread the majority opinion for the 15th time. Justice Raymond Collier had written, "The legislature's intent during declared emergencies implies broad functional immunity for state-directed operations." Implies, that word bothered her. Implied intent is interpretation, and interpretation is power. Her clerk entered quietly. "Justice, the press is calling your dissent historic." She didn't look up. "Historic isn't always good." She closed the opinion. "What's the public reaction?" "Angry." She nodded faintly. "Anger fades. Precedent does not." But what troubled her more was not public outrage. It was something internal. During deliberations, Collier had referenced a legislative policy brief not included in formal submissions. At the time, she assumed it was part of background research. Now she wasn't so sure. She called her clerk back. "Retrieve all amicus filings and cited policy materials." Hours later, the clerk returned. "It's not here." "What's not here?" "The policy brief Justice Collier referenced." Silence. "Are you certain?" "Yes." Justice Vargas stared at the ceiling for a long moment. Supreme Court deliberations are confidential, sacred, untouchable. But missing materials? That was procedural irregularity, and irregularity inside the highest court is seismic. Back at the cafe, Aaron leaned closer. "There's another piece," he said quietly. "What?" Redmont's legal team hired a former clerk from Justice Collier's chambers. Maya's eyes narrowed. "When?" 2 months before the court granted review. The air changed. Former clerk. Inside knowledge. Procedural insight. Was that illegal? Not necessarily. Was it strategic? Absolutely, but it didn't prove misconduct, it proved proximity. Maya exhaled slowly. "So what do we do?" Aaron's voice was calm. "We don't accuse, we expose." "How?" "By asking questions no one else wants to." That night, Aaron filed a public records request for communications between Redmont lobbyists and legislative aides surrounding emergency liability policy. At the same time, Justice Vargas made a quiet internal request for clarification regarding the policy brief referenced in conference. 2 separate investigations, moving toward the same pressure point. Subscribe right now if you think. Truth rarely travels alone. 3 weeks passed, then the first crack appeared. Aaron received a response to his records request. Most of it was redacted, but one email chain slipped through. A legislative aide had forwarded a draft policy memo to Redmont's legal counsel with a single line. This may assist upcoming appellate strategy. Upcoming before oral arguments. Before the Supreme Court ruling. Maya stared at the timestamp. 4 days before the court agreed to hear the appeal. That means they knew, she whispered. Aaron nodded. They were preparing interpretation arguments before review was granted, which suggested confidence, but confidence based on what? Meanwhile, inside the court, Justice Vargas received her answer. The clerk entered with a sealed envelope. It was archived separately, he said. She opened it. The policy brief. It was authored not by the legislature but by a private legal research foundation funded in part by corporate donors, including Redmont subsidiaries. Her pulse slowed deliberately. She read the margin annotations. Justice Collier had underlined sections arguing for functional immunity necessity during emergency, privatization. Redmont was private. Justice Vargas closed the folder. If that brief had influenced the majority, and if it had not been formally entered, then the line between advocacy and adjudication had blurred, and when that happens in the highest court, people start using phrases like, one of the worst Supreme Court decisions. But this was no longer about public opinion. This was about institutional integrity. Justice Vargas made a choice. She requested an internal ethics review. Quietly, confidentially, dangerously. Because challenging a fellow justice is not political, it's existential. Outside, public pressure intensified. Protests formed outside the courthouse steps. Editorial boards called for transparency. Maya watched from her living room. She didn't want chaos. She wanted clarity. Her phone rang. Aaron. It's bigger, he said. What is? The former clerk hired by Redmont? Yes. He drafted early language on functional immunity months before the case was accepted. Maya felt cold. How do you know? He published a law review article previewing the argument, before the ruling, before review, which meant the legal theory wasn't reactive. It was positioned, carefully, deliberately, and now, the State Bar Association announced a preliminary inquiry into procedural conduct surrounding the ruling. Not reversal, not impeachment, inquiry. Still, for a Supreme Court decision to face inquiry was unprecedented. Justice Collier issued a public statement. The integrity of this court remains uncompromised. Short, defensive controlled, but behind closed doors, pressure mounted. Because if internal materials showed reliance on privately funded briefs, the optics alone could fracture public trust. And public trust is the oxygen of the judiciary. Without it, authority suffocates. Maya stood outside the courthouse one evening as protesters gathered. A reporter approached her. Mrs. Bennett, do you believe this was one of the worst Supreme Court decisions in state history? She didn't answer immediately, because the question wasn't emotional anymore. It was systemic. I believe, she said slowly, that decisions without accountability become dangerous, and that sentence would echo further than she expected. Inside the court, the Ethics Review Committee requested voluntary disclosure from all justices regarding external research influences. Justice Vargas complied immediately. Justice Collier requested time. Time is powerful, but sometimes time also reveals. And what would be revealed next would determine whether the ruling stood uncontested or whether history would record it as something far more troubling than one of the worst Supreme Court decisions. The letter was marked confidential, Judicial Ethics Review. It arrived on a Thursday morning. No press notice. No announcement, no leak, just a sealed envelope delivered to each justice's private chamber. Justice Elena Vargas opened hers immediately. Justice Raymond Collier did not. If you believe institutions are strongest when they examine themselves, subscribe to Sweet Justice right now, because this is where power faces something rarer than public outrage. It faces scrutiny from within. The review committee's language was precise, measured, careful. It did not accuse, it did not speculate. It stated facts. A privately funded legal policy brief was cited during internal conference discussion. The brief was not formally entered into the case record. The brief's funding sources included subsidiaries connected to Redmont Security Solutions. A former clerk of Justice Collier had authored portions of that brief prior to being retained by Redmont's appellate counsel. It stopped short of declaring misconduct, but it ended with one line that echoed louder than any accusation. The appearance of impartiality may have been compromised. Appearance. In the judiciary, appearance is nearly as critical as reality. Justice Vargas exhaled slowly. This was no longer about a dissenting opinion. This was about the court itself. Across the hall, Justice Collier finally opened his envelope. He read it once, then again. His jaw tightened slightly. Not in panic. In calculation, because ethics review did not automatically mean reversal, but it meant exposure. And exposure in a high court is destabilizing. Subscribe now if you understand that. Sometimes the biggest courtroom drama happens where cameras aren't allowed. Outside the courthouse, Aaron Pike received a message from a source inside the Judicial Administrative Office. Ethics review confirms undocumented external material. He stared at the message, then immediately called Maya. It's official, he said. What does that mean? She asked. It means the narrative just changed. Within hours, the story broke. Major outlets ran with variations of the same headline. Ethics review questions, Supreme Court decision process. Was it one of the worst Supreme Court decisions? Or a procedural failure? Public reaction intensified, but something else happened. Law professors began writing op-eds. Former judges gave interviews. Not about Daniel Bennett's case alone, but about precedent, because if external, privately funded materials influenced interpretation, every future emergency immunity case could be challenged. Precedent, once stable, was now unstable, and instability at the top spreads downward. Justice Vargas requested a private conference, all 7 justices present, closed door, no clerks, no recorders, just marble walls and consequence. Collier spoke first. The review questions optics, not legality. Vargas responded calmly. Optics are legitimacy. Another justice leaned forward. Was the brief circulated before deliberation? Collier paused. Yes. Was its funding source disclosed? No. Silence settled heavily. That omission, Vargas said evenly, is not trivial. It was research, Collier countered. It was advocacy. It was relevant. It was funded by a party with direct financial interest. No one raised their voice. But the temperature shifted. Another justice finally spoke. The public is questioning whether this was one of the worst Supreme Court decisions in history. Collier's eyes hardened. Public opinion does not govern law, Vargas replied softly, but public trust sustains it. That landed, because courts do not have armies. They have legitimacy. Without it, compliance erodes. And when compliance erodes, authority becomes fragile. Meanwhile, Maya Bennett stood outside her home watching coverage unfold. She did not celebrate, because even if the court acknowledged procedural flaws, her husband was still gone, and the original ruling still stood. Her phone rang again. Aaron, there's movement, he said. What kind? The ethics committee is recommending reconsideration. Her breath caught. Reversal? Not automatically, but reopening. Reopening a Supreme Court decision is rare, almost unheard of. It requires extraordinary procedural concern, and now the court faced exactly that. 2 weeks later, an announcement was made. Brief, measured. The court will convene to consider whether procedural irregularities warrant rehearing in Bennett v. Redmont. The state froze. Legal analysts debated implications. Political figures tread carefully. Because this was no longer about ideology. It was about institutional credibility. Subscribe right now if you believe accountability should reach even the highest bench. The rehearing was scheduled for a limited session, not a full retrial, but argument on whether the original interpretation had been improperly influenced. Maya returned to the courtroom. The same marble, the same bench, the same justices. But the atmosphere was different, heavier. Collier looked composed, but slightly less certain. Vargas looked steady, grounded. Redmont's legal team appeared less confident than before, because now the conversation wasn't solely about immunity. It was about integrity. The questioning was sharper, more direct. One justice asked Redmont's counsel, "Did your firm provide research materials to any member of this court prior to deliberation?" The attorney hesitated. "We provide academic resources widely. That is not my question." Silence. Another justice turned to Collier. "Was the funding source of the policy brief known at the time of reliance?" Collier answered evenly, "No." "And, had it been known?" A pause. "It may have prompted further inquiry. That was the closest thing to concession he would offer. But it was enough, because concession at that level signals vulnerability." 3 months later, the court issued a revised opinion, not unanimous, but decisive. The original majority was vacated. The new ruling narrowed immunity interpretation. Private contractors performing state functions during emergency designations were no longer automatically shielded from civil liability unless explicitly named by statute. Daniel Bennett's case was reinstated. The original jury award was restored. The courtroom erupted, not with chaos, but with exhale. Maya felt her knees weaken, not from triumph, from relief. It was not revenge, it was correction. Justice Vargas's revised concurrence included a powerful line. Courts must not only be impartial, they must be unquestionably independent from private influence. It would be quoted for years. Justice Collier did not resign. He did not admit wrongdoing, but his authorship would forever carry an asterisk in academic discussions. Law schools would teach the case, not merely as one of the worst Supreme Court decisions, but as one of the most consequential corrections. Because the worst decisions are not always those that stand, but those that test whether institutions can self-correct. Outside the courthouse, reporters surrounded Maya again. "Mrs. Bennett, do you feel justice has been served?" She held Daniel's photograph firmly. "I feel heard," she said, "and sometimes that's the beginning of justice." Months later, Redmont settled fully. Internal compliance reforms were mandated. Legislative oversight on emergency contracting tightened. Ethics disclosure procedures for justices were strengthened. No one declared victory, but something fundamental had shifted. Public trust, shaken, had been examined, and examination restored strength. If you believe that even the highest courts must answer to principle, subscribe to Sweet Justice, because justice isn't perfect. It's deliberate, and when it falters, it must have the courage to correct itself. That is the difference between power and legitimacy, and that is why history will remember this case, not just as one of the worst Supreme Court decisions, but as the moment the court chose accountability over pride.